Hey everyone, I'm Diana Davison, advocate for the falsely accused and wrongfully convicted, and I'm here with criminal lawyer Joseph Neuberger.
Hi.
And we've been talking a lot about stereotypes. Everybody knows about stereotypes about women and what's called rape myths, but there's not as much talk as there should be about the stereotypes that are at play about men in the trial.
Yeah, so we've been experiencing over the last, year or year and a half that cases are still unfolding in a way where a male accused who's testifying about how an event would have unfolded with a woman that he was with. It could be how the evening unfolded and how the sexual interaction unfolded. But they're met with cross-examination based upon certain particular stereotypes about male aggression and male sexual aggression. So, for example, an individual case that we had in common where an individual was being cross-examined on how they were kissing with a young lady, and the idea was that while kissing you must have sex on your mind. And so the idea was that it's preposterous to assume that when the accused indicated or was trying to say that there was a different level of intimacy between kissing and actual having intercourse with somebody who they've just sort of met and they're getting to know, that was really quite preposterous. And this is a really difficult type of stereotype that we're still trying to root out of the justice process, because as the criminal justice process has moved forward in recognizing stereotypes involving female complainants, we still see a perpetuation of cross-examination and reasoning based upon male stereotypes of aggression and sexual aggression. And we have to really push the narrative to get judges and prosecutors to understand that this is an impermissible line of cross-examination and reasoning to try and discount the evidence of a male accused.
Well, and it's interesting too because sometimes these stereotypes are actually the same stereotype operating in reverse. So there's a case that's going to Supreme Court now where they're saying they looked at text messages prior to an encounter and they said, well, the guy was expecting sex, but more significantly, the woman said that she didn't want to have sex that weekend. So they found that she wouldn't have consented. Well, if a woman can't, give advance consent, saying, she's more likely to consent than her saying no, I mean, she's still open to change her mind. So it's the same myth, but they operate really kind of hide themselves when they're operating in reverse and they're playing out against men.
Yeah, I mean, courts have to be very careful about what assumptions they want to make about what a complainant will do, even though we're rooting out the stereotypes that we know that lead to impermissible reasoning and really erroneous findings. We still have to be very careful about how people will change their minds or how human interaction really plays out in the course of a relationship or the interaction. But similarly, against men, there is a whole host of male stereotypes that are playing out in cross-examination to try and suggest that the evidence of a particular male accused is implausible or preposterous or not credible or reliable. And we have to push that narrative, and we're working very hard to do that. So there's the case, I may mispronounce it, Chepik, which has come out from the Court of Appeal, which is a very strong direction to the courts, to the trial courts, to not use particular male stereotypes of aggression and sexual aggression in order to discount evidence. In spite of that, we're still seeing this line of cross-examination. And, we talk also about, we've spoken a lot about how text messaging is really quite prevalent because amongst younger people, younger than me, text messaging is quite common. And so after an encounter or an evening, it may come out a day later or 2 days later that somebody makes an accusation. The female says, I was very uncomfortable. This was not what I expected, and I feel that I've been wronged in some way. And then the man will respond by apologizing and say, I'm sorry, I didn't mean to make you feel that way. I really am quite sorry about this. And what will happen is police and prosecution will seize on these text messages and use them as admissions of guilt, that in fact the person is admitting that they did something wrong, when in fact the person may simply just be acknowledging the emotions of the other individual, or as we discuss about it, not invalidating how another person feels, but somehow this is being perceived as an admission of guilt. And again, it's a narrative to push. It's based on a myth and a stereotype about how a man should react. The assumption is that if they meet with an accusation, they should be saying, what are you talking about? Are you crazy? That's not what happened. But people who are, sensitive, well socialized individuals may say, I don't want to invalidate how she's feeling. I certainly want to acknowledge I never wanted to make her feel bad, or I didn't want to make her hurt in any way or perceive me this way, and so I'm apologizing. But an apologizing does not mean that somebody's admitting guilt. But it's amazing how prevalent that using these text messages has become such a mantra for trying to establish criminal liability.
Well, I think they can be treated, because they're in writing, they can be treated as if they're more compelling evidence than what somebody is saying. So, but of course, we also know with text messages, we have things like emojis, because they're notoriously difficult to interpret, and you can interpret those in a bunch of different ways. Quite often, people have to clarify to somebody because they don't come across properly. But yet, when these messages go into court, they're treated as if this is like a gold standard of evidence because it's all in writing.
Absolutely correct. And we have some direction, as you know, from the courts now about some of the limitations that can be used of text messages, because the method of communication can be short form, there can be emojis, the emotion, as you've discussed before, doesn't quite come across in the text messaging. And so there is a fair degree of misinterpretation of the text messages. And so there's some fairly good guidance from the appellate courts about how these can be used. But nevertheless, it's still being used and in perpetuating this type of stereotype that a man would not apologize or recognize how somebody's feeling unless they were guilty of that offense. And this is something we have to be really careful about and use these messages in a more nuanced way in order to push back against those stereotypes, because this does not mean that somebody's guilty.
And intriguingly, in terms of different treatment for men and women as well, if a complainant, which usually are female, if they go in with text messages, the police will take those and use them in court. But if the texts are in the possession of the accused, you have to do all these applications to try and get the evidence in. So it's an interesting imbalance in the treatment of evidence that's allowed in court.
It's a very good point, because the assumption is whatever comes from the complainant's phone or computer is automatically admissible. But if we want to use text messages, there's tons of hoops to jump through. And then, God forbid, if we know that there's other evidence in somebody else's computer or cell phone, and we request that by way of disclosure, we're just not going to get that material. And so there is this very stark imbalance in the system right now that we got to work and get through and enhance investigation so that we prevent against wrongful convictions.
Yeah, absolutely. But there's some good decisions coming out, like Sepich and a couple other ones. I try and track them all. But I am starting to see a little bit of change, so hopefully we'll see more of that.
We'll get there, and we'll talk about it as it develops.
Right. Thanks.
Thank you. Thank you.